Good day, everyone. My name is Ruod. I am part of the HRI team, and today we will be looking at the working group on arbitrary detention, its process, and the experiences of organizations utilizing the mechanism. The Lawyering on the Margins Network, a global network of lawyers and paralegals working in access to justice for people living with HIV, people who use drugs, sex workers, and LGBTQIA plus communities, together with a working group, will be debuting a video introducing the basic process of the WGAD. We are honored to be joined today by amazing speakers who will share with us their expertise on the matter. We encourage everyone to participate through the chat box and leave questions for our speakers, which we'll be taking up at the end of the session. We will be opening with a background on arbitrary detention, followed by the premiere of the video, and then a presentation by the WGID, after which we will have an organization reflect on their experience using the mechanism. Lastly, we will take the questions from the audience. We hope you're all ready for the session, and to welcome us all today, we have Jada Jareli, Senior Analyst of the Human Rights and Justice Team in the Harm Reduction International organization. Giada is a senior analyst and she monitors trends on rights violations committed in the name of drug control, authors reports, and analyzes and coordinates advocacy with the UN and other institutional actors. Giada holds a law degree from the University of Torino, Italy, and an LLM in human rights, conflict, and justice from SOAS University of London, and is a member of the Advocacy Coordination Working Group of the World Coalition Against the Death Penalty. Giada, you have the floor.
Thanks, Rod. Good morning, good afternoon, good evening, everyone. Thanks for being here at the second day of Constellations. And also thanks for joining this session on maximizing strategies to engage with the working group on arbitrary detention. We're very fortunate today to have a member of the working group on arbitrary detention here with us, as well as Rod was mentioning, a lawyer with direct expertise engaging with the working group. And one of the key objectives of today's conversation is really not to get lost of the legalese of international organizations and the UN, but really to understand how all of us, lawyers, non-lawyers, activists, members of communities can engage with and make the most of the opportunities and the support that the working group on arbitrary detention provides. Now, I've been given the task, and maybe I can put my slides up right now. I've been given the task to open this session and to give a brief overview and introduction to the topic of arbitrary detention, particularly as it relates to criminalized and marginalized groups, such as people who use drugs, sex workers, LGBTQI+ individuals. I try to make it as little boring, as non-boring as possible, and I also have to say I'm a bit intimidated by having to do it in front of a member of the UN Working Group on Arbitrary Detention. So I hope Dr. Miriam will be patient with me, and I'll try my best. So starting from the basics, what do we mean when we talk about arbitrary detention? Arbitrary detention or deprivation of liberty is actually any situation in which a person is held in a place without their free consent. And so, of course, when we talk about it, our mind goes straight to prisons, but it's actually much broader than the context of prisons. There are other detention settings or other situations in which a person is deprived of their liberty. We talk about forced hospitalization, for example, compulsory rehabilitation, or even detention limitation camps. Also, deprivation of liberty and detention can happen both in the public or in a private way. Of course, not all cases of deprivation of liberty are arbitrary. There are some situations in which it's completely legal to keep a person against him. But there are cases in which deprivation of liberty gets to be qualified as arbitrary. This is a standard that really has evolved in time and that's been clarified. Better. I continue. I think we're all used to now? Can you hear me now?
Hey, Giada. Can we try your mic again?
Does it work now?
Yes. Now it's
Oh,
perfect.
so it was the slides. Okay, nobody wants to see the slides, so I'll do without them. I'm really sorry about
Okay.
it.
No
Uh,
worries.
we all went through too much PowerPoint in the past couple of years. So sorry again, and just to, I don't know where we got, but basically, as we were saying, not all situations of detention are arbitrary, but there are cases in which it can be defined as such. This is a standard that has evolved in time and has been clarified by authoritative international bodies, including the Working Group on Arbitrary Detention. And what we understand now is that arbitrariness can mean against the law. So if a person is detained illegally, of course, that's a situation of arbitrary detention. But there are also other cases in which we can get to this definition being met. In particular, arbitrariness is not to be equated merely with against the law, but must be interpreted more broadly to include elements of inappropriateness, injustice, lack of due process, or lack of predictability. And I'll pause on some of these elements later. This simply put means that there can be cases, and there actually are a lot of cases, when a situation of detention is in line with national law, so strictly speaking is actually legal, but is still to be considered arbitrary, and so against human rights standards, because it has some of those elements that I mentioned, for example, the element of injustice. And that is actually what happens in a lot of cases with detention of, for example, people who engage in the drug market or people who engage in sex work. Arbitrary detention is prohibited, of course. It's a prohibition that's enshrined in all major international and regional human rights treaties, but there's also an understanding now that the prohibition of arbitrary detention is binding under international customary law. What does that mean for all of us? That it doesn't really matter which country you come from and which country which treaties or which conventions your country, your government signed. It's a prohibition that's universal and everyone is protected by it. Because of their being humans, essentially. It's also a prohibition which is non-derogable, and that means that there are no cases, no situation in which a form of arbitrary detention can be deemed acceptable. So basically, it's an absolute prohibition. There is never a situation where a state can justify a situation of arbitrary detention. So this is the theory in its smallest possible nutshell, but what I wanted to do was give you a few examples of arbitrary detention or human rights violations that result in arbitration based on jurisprudence and work by the Working Group on Arbitrary Detention. So the reports, the thematic reports of the Working Group, the recommendations to state, the reports from country visits, with a particular focus on criminalized and marginalized groups, which because of their status or because of the position of sort of lack of power within society that they have, are disproportionately exposed and disproportionately experience arbitrary detention. This is also, I'm just going to touch upon just a few examples. These are really just the tip of the iceberg. If you want to find out more, what I encourage you to do is to look into the work of the working group, and particularly for what concerns people who use drugs and their communities, look at a study, which we will post in the chat if we can, that was published in 2021 by the working group, specifically on arbitrary detention in the context of drug policies. And this gives you a very comprehensive understanding of all the situations in which a situation of a case of detention can be defined as arbitrary because of its characteristics. Hopefully, these few examples will also give you a sense of the many circumstances in which the work of the working group can be useful to you. So all of the cases in which lawyers and activists can reach out to the working group for help and for support. The first example I want to give is that of detention based on discriminatory grounds. As I mentioned, in the cases where detention is not against national law, so it's legal, but still is arbitrary because it contains an element of injustice. The working group distinguishes different categories of arbitrary detention, and one is any deprivation of liberty for reasons of discrimination based, among others, on ethnic or social origin, economic condition, opinion, gender, sexual orientation, or disability or other status. So from here, it's clear already, as was also confirmed by the working group in 2021, that arrest and detention on the basis of actual or perceived sexual orientation or gender identity is in itself arbitrary. Another example is that of criminalization of poverty through laws that punish offenses such as vagrancy or loitering or rough sleeping, which in fact target people who are not in a position to shelter them and are to live in public spaces. In 2021, the working group, and I'm quoting, expressed concern for the discriminatory application of public order offenses, such as loitering, vagrancy, public nuisance, which are often applied to women experiencing poverty and women sex workers. In the same source, and this is again very important, the working group clarified that the direct or indirect criminalization of sex workers is discriminatory and a violation of international law. Another case is that of pre-trial detention, being mandatory or overused. Pre-trial detention is that situation where a person is arrested, is put in jail, let's say, so it's still to be considered innocent, but is put there and kept there awaiting a trial. So arbitrary pre-trial detention should never be mandatory. It should always be based on the situation of the person and on the offense. However, in many cases, in many countries, it is actually mandatory, so automatic and inescapable for drug-related offenses. In other countries, pre-trial detention is overused and is too lengthy, and it contributes to prison overcrowding. So one of the examples that the working group gives in their 2021 report is that of the Philippines, where pre-trial detention, so detention while a person has to be considered innocent, is mandatory for drug offenses, and a person stays in pre-trial detention for an average of almost 2 years. Another case, which is sadly familiar to many of us, is that of arbitrary compulsory detention and treatment of drug use or of sexual orientation. So the examples are the one of the privation of liberty of LGBTQI+ individuals to subject them to the so-called conversion therapy, which, as we know, has no kind of scientific basis. And again, what the working group has clarified is that, and I quote, LGBTQI+ persons must not be detained for the purposes of forcibly administering such therapies, both in private and in public facilities, such as hospitals, psychiatric institutions, specialized camps, places of worships, or even in the home. So there are even situations in which keeping a person in their home without their consent to undergo a kind of therapy, which is actually not therapy but violence, can be qualified as arbitrary detention, and so brought to the working group. The other case, as I was mentioning, is that of compulsory treatment of people who use drugs in public or private detention or rehab centers, which, as we know, are centered around abstinence and other non-evidence-based forms of treatment, which are best described not as treatment, but actually as violence and ill treatment. In Asia alone and in government-run facilities alone, we know of at least 500,000 people detained every year. So again, this is not a niche issue, but it's something that affects a lot of people and a lot of communities. The last case I wanted to mention is that of the death penalty and its imposition for crimes for which the death penalty shouldn't be applied according to international law. So according to international law, there are only a very limited set of crimes to which states can impose the death penalty, which are essentially crimes involving intentional killing. Everything else is against international law or international standards. if a person is convicted and put on death row for crimes which are not those most serious crimes, then that detention is found to be arbitrary. And two cases I want to give is one, the case of the death penalty for consensual same-sex relations or homosexuality, which are still found in 11 countries. And then secondly, the death penalty for drug offenses, which HRI monitors, which is still in place in the legislation of 35 countries and which led to at least 4,000 executions confirmed in the last 10 years alone. So based on this work, what are some of the recommendations that the working group gave? And again, I'm going to quote recommendations that have been given by the working group either in annual or thematic reports or at the end of country visits. And these are just some of many that can be found and that can be used potentially in advocacy. The first one is a recommendation to state to decriminalize the use, possession, acquisition, or cultivation of drugs for personal use, including the possession of paraphernalia, to make harm reduction available in prison, including opioid antagonists such as naloxone, to take measures to protect the rights of LGBTQI+ persons in detention, and to address their specific needs, including establishing appropriate gender-specific conditions of detention, to repeal laws which directly or effectively criminalize sex work, as we were mentioning before, and seize any practices that target, arrest, and detain women in relation to sex work. And finally, to amend legislation, policy, and practice so that all treatment for drug use disorders, including for drug dependency, is evidence-based, strictly voluntary, and based on informed consent. So I'll stop here. I'm happy to answer any questions later. I look forward to the debate, and I give the floor back to Rod. Thank you.
Thank you so much, Gianna. Thanks for giving us a background on arbitrary detention. It truly gave us a more comprehensive perspective on the matter. And now we will be watching the premiere of the short video on what the working group on arbitrary detention is and what we can do for cases on arbitrary detention. Let's play the video.
The UN Working Group on Arbitrary Detention is one of the thematic special procedures that consists of independent human rights experts. Established in 1991, the working group investigates alleged cases of arbitrary detention through urgent appeals and communications to the concerned governments. The working group receives individual complaints, leading to the adoption of opinions as to the arbitrariness of the detention. The working group also conducts country visits to assess the situation of deprivation of liberty in the country. The basic principles and guidelines on remedies and procedures on the right of persons deprived of their liberty to bring proceedings before a court recognize that everyone has the right to be free from arbitrary or unlawful deprivation of liberty. This includes people who use drugs, people living with HIV, LGBTIQ+ individuals, and sex workers, among other marginalized groups. The working group has acknowledged that these marginalized groups are particularly vulnerable to discrimination, violence, torture, and ill treatment contrary to international human rights law when deprived of their liberty. The working group has also prepared reports, deliberations, and issued opinions to discuss deprivation of liberty faced by vulnerable and marginalized groups. In 2021, the working group published a study on arbitrary detention relating to drugs and raised the various human rights violations in the context of the war on drugs, including unfair trials, and highlighted that imprisonment for drug-related offenses should be a last resort and, in principle, should be used only for serious crimes. On the issue of sex work, the working group has argued that discriminatory use of laws and policies to regulate women's control over their own bodies and sexual behavior, including in relation to sex work, is a severe and unjustified form of state control. Therefore, such deprivation of liberty violates the ICCPR. The working group has also expressed its opinion on the discriminatory nature of detention motivated by sexual orientation and health status, including HIV/AIDS and other serious communicable or chronic diseases. You don't need to be a lawyer or expert to engage with the working group. Its various mechanisms can be utilized by anyone facing arbitrary arrest or detention, including marginalized and vulnerable groups in the context of the war on drugs and their allies. Learn more on how to do this today.
Again, we'd like to acknowledge the lawyer of the Marginalised and the working group on arbitrary detention for the making and the content of this video. Here to give us a better overview of the working group on arbitrary detention, we are honored to have Dr. Miriam Estrada Castillo, the Chair Rapporteur of the UN Working Group on Arbitrary Detention. Dr. Miriam is a professor of international law, international criminal law, and human rights, and the director of the UNESCO Chair sa Casa Grande University of Guayaquil, Ecuador. I hope I pronounced that right, Dr. Miriam. She is also a visiting professor at Barnes College in New York and Palestine. Professor Estrada worked for the United Nations Security Council Counterterrorism Committee Executive Directorate as an international prosecutor at Timor-Leste, being part of the first 100 Rohingya civilian experts deployed in a peacekeeping mission by the UN. She is a former vice chairperson of the Committee for the Elimination of All Forms of Discrimination Against Women, and member of the group which drafted the CEDAW optional protocol. Dr. Estrada was the Latin America Regional Advisor on Gender, Human Rights, and Culture of Peace for UNESCO. She has been visiting professor and international leading expert on human rights at the Ruod Wallenberg Institute of Human Rights and Humanitarian Law. Professor in residence at the UN University for Peace and at the Australian National University. Former Minister of Social Affairs and a former president of the National Court for Minors in Ecuador. She is the author of the Children's and Family Law of her country and is known as the founder of the Human Rights Education in Ecuador. She has written profusely about human rights, gender, and civil and political rights. We are so honored to have you here, Dr. Miriam. You have the floor.
Thank you so very much for that kind presentation. Thank you again, Ruth. As it was mentioned, my name is Miriam Estrada, and I am the current chair of the working group on arbitrary detention. I just want to commence by thanking with all my heart the organizers on behalf of the working group for the invitation. We consider it a privilege and an honor. This is a really important topic for everybody, and you have provided us with the opportunity to explain a little bit more about our mandate. Furthermore, we are here to strengthen our relations with you all, which is vital for the success of our work. I was a little nervous when I saw the video, thinking that maybe I wouldn't have to add anything, but there are certain issues that I believe you should be aware of. So first, allow me to give you this inside view of our work, methods, and activities in general. As it has been said, the working group is an UN body consisting in 5 experts, but these 5 experts come from around the different regions of the world: Africa, Eastern and Western Europe, Asia Pacific, and Latin American and the Caribbean. That's me. We are all experts on human rights law, but we look particularly over the issues that are related to our region when it comes to the complaints that we receive. We sit in Geneva 3 times per year, normally April, August, and November, and we are selected following a rigorous selection process administered by the Human Rights Council. Our mandate lasts 6 years, no renovation. In terms of our thinking, our philosophy, our way to address the problems, as you have heard already, we have been founded 30 years ago, so the mentality and the way to solve the problems has evolved over the years. The Commission, as you know, established the working group in 1991. So imagine we have moved our views to the contemporary problems that are now problems for the whole humanity. Before talking about our methods of work, let me underline some extremely important differences in relation to other special procedures or treaty bodies, which I believe is very important for you to be aware of. First and more important, to present a complaint before the working group, you don't have to exhaust the national legal mechanism, the national legal different stages. You can come to us in the moment that you have been detained. Your family, your friends, the NGO that represents you, the lawyer, anyone can come to us immediately, so and directly. So this is something which is very important. Secondly, we work essentially within the framework of international law, but particularly with the Universal Declaration of Human Rights, that, as you very well know, is broadly known and respected all over the world. And after that, we focus on the international covenants on civil and political rights, the Convention Against Torture, and also the Convention Against Enforced Disappearance. Of course, we also look at all other conventions, human rights conventions, but these are the ones that we use the most. Thirdly, which is important also, it doesn't matter how much time has passed since you were detained, or if you are already at liberty. No, you still can come to us. Why? Because the main point is to underline and to redress the injustice that was committed against you by an arbitrary detention activity. So it doesn't matter that this has happened 3, 5, 10, 18 years ago. You still can come to us. And it doesn't matter that you are already at liberty, as I said, that you have been freed. No, you can still come to us in order to underline why and to receive redress and compensation of when you have been detained arbitrarily. And also, fourthly, that has been already mentioned, it doesn't matter that you have been detained in accordance to the national law. We insist on that very much. As long as your national law goes and is in compliance with international law, we don't have any problem. In other cases, still, this is an arbitrary detention. Now, let's go a little bit in depth to our methods of work. Some of the most important functions that we carry in our work is that we adopt opinions. This has also been mentioned here. But these opinions are the ways in which that we use to solve the cases, to give you a response on the problems or the crimes actually that has been committed against you. So every year we adopt around 80 to 90 opinions. The experts receive the opinions in accordance to the regions they represent. So it's quite a heavy workload, but I should do stress that this is the most effective part of our work because it allowed us not only to engage on specific issues, but to set up our jurisprudence into particular subjects. So I should tell you that the working group looks at detention in a very structured way. We have identified 5 categories on what we can call arbitrary detention, because there is not a specific definition of arbitrary detention in international law. So, category number 1, there is no law, no reason, the law is too vague, you haven't been told why you are detained, you haven't been presented with an arrest warrant, etc. That's number 1. Number 2, if you are exercising any kind of your human rights that has been recognized by your country, that your country is part of the international convention, and because of that you are detained, then that is an arbitrary detention. Let me give you an example. If you are in a peaceful protest, for example, and you are detained, that's arbitrary detention. You have the right to protest. If you are detained because you have written something, because you have voiced your opinion, because you have political activities, or because you have expressed what you think, all those issues are arbitrary if you get detained. So number 3 is every time that you don't receive due process and fair trial. You know, in order to be a judge and obtain a sentence, you have to respect the law. And the law goes by number 1, you are considered always innocent until proven guilty. And this is the reason why we go immediately to the presumption of innocence. And this is also why we are completely against, and we have already established it, that to have this kind of compulsory, obligatory pre-trial detention is absolutely illegal and unconstitutional. Although I also can present to you some, as an example, particularly in Latin America, some places in Asia also, where a pre-trial mandatory detention is even at the level of constitutional law. The last case that we saw in this last session was Mexico. And you can be in pre-trial detention not 1 year, 2 or 5. We have had people that has been in pre-trial detention by 17 years. Could you imagine such a thing? Well, number 4 category is when you are detained for administrative issues. So this is normally related to migrants, asylum seekers, and refugees. And number 5, it has been already explained, is because any form of discrimination. Well, that's the part of the opinions. When we receive a complaint from you, what we do is to check the situation in which you were detained, the way in which you were detained, and contrast it with the different categories that we have. If we find that this has been broken, then it's arbitrary, and we request to the state immediately that you should get a release. This is important to be aware of. We receive complaints from the people. We distribute these complaints. After that, guarding the confidentiality, we go to the state and we ask the state to say, what are the explanations that they can give us? When we receive this, we also give the source. We never called the person, but the source. We also give the source the opportunity to comment on what the state has responded. And after that, we take our decision. So this is why the opinion, which is our primary way of engaging with society, is the most important activity. But also, in cases where the situation is desperate, we issue something which is known urgent appeals. This is a quicker process when a person is, in just to be executed or just dying because he's too sick or tortured in a very difficult situation. In these cases, generally, we receive the support and we issue this urgent appeal supported by other colleagues from different special procedures mandates. Another activity that we have and that we carry on is the country visits. On these visits, and this is important, we have, of course, a meeting with the authorities, a meeting with the police, a meeting with the directors of the facilities, but more importantly, a meeting with those who are detained, with the prisoners. And we don't go only to the prison facilities. We go also to hospitals, to places where people who are, for example, being treated by drug abuse are placed. We go to juvenile places, and we go to these places that are established to keep their older people. And we talk to all of them so that they can tell us exactly how things are going, and we can imagine and draw exactly the picture. In this particular issue, in the country visits, we really need the participation of the civil society. First, because we cannot go to any country if we don't receive an invitation. And because we are very critical and we say exactly what we see, countries are a little reluctant to invite us. But with the pressure of the civil society, we have been, going around the world to several countries, and we receive direct information also in a special session with the civil society. Going to another activity that we have, we write deliberations that address particular problems, or if requested by the Human Rights Council, we also produce this kind of studies as the one that you have here now about drugs. In September every year, we present our annual report to the Human Rights Council. That is another moment in which you can engage directly with the group, because you can talk, for a few minutes, you can talk and you can express your doubts or your problems. Let me say here that the working group has a policy of open doors. Anyone can ask for a meeting. What you cannot do is to participate in our sessions. These are confidential and these are closed, but you can talk even with a working group represented by either by yourself or with the support of a civil society organization, an NGO. Well, I was going to say bien in Spanish. Well, we look with particular interest people that are using drugs, as you have already explained. We look to the situation of human rights defenders all over the world. We take care of freedom of expression, people who are activists, political activists, artists, people who try to keep human rights alive and are fighting for human rights for all. We look to the necessity that everybody will receive due diligence exactly and to be treated with fairness. That is our most important issue. Now, when a case comes, this is something also that must be clarified. When we are looking to a case, when we have the same nationality, for example, a case coming from Ecuador, then because of ethics, I cannot participate. I cannot even be in the room when this case is analyzed. Well, I have tried to, like a picture for you, the most important issues related to our work and mandate. And I believe that you have now a broader picture of it. And well, I stand here expressing again my gratitude for any question you want to ask, or if you want some more explanation in a particular situation. Aha, before I forget, I should say that there are several ways from the civil society that for engaging with us. Visits are a marvelous, a brilliant opportunity, but also you can do exactly what we are doing now. Invite people from or members of the working group so you discuss and you disseminate our work. You can talk to us, you can participate, you can support the victims. You go to the website of the Office of the High Commissioner of Human Rights, you will find there a questionnaire. This questionnaire has been updated now, but still the questionnaire is not necessarily like a, you have, yes, I know, you are not obliged to follow the questionnaire. You don't need to be a lawyer. What you need to be, unfortunately, to come to us is a victim. So thank you again very much. and I stand ready to answer any question you would like to ask. Thank you again.
Thank you, Dr. Miriam. We're so honored again to have you here with us. Thank you for giving us a better understanding of the working group on arbitrary detention process. Again, we are encouraging everyone to use the chat box down below to send off any of your comments and questions, which we will take up at the end of our session. So before that, we're down to our last speaker for today. We'll be sharing their organization's experience working with a working group on arbitrary detention. So we have with us Adrian Juko, the Executive Director of Human Rights Awareness and Promotion Forum. Adrian is a Ugandan human rights lawyer and advocate. He is the Executive Director of HRAF, or Human Rights Awareness and Promotion Forum. He's the current chair of the legal committee and former coordinator of the Civil Society Coalition on Human Rights and Constitutional Law, which coordinated civil society efforts to nullify Uganda's Anti-Homosexuality Act and which won the U.S. State Department's Human Rights Defenders Award 2011. Adrian coordinated the successful legal efforts to challenge the Anti-Homosexuality Act 2014 in Uganda's Constitutional Court and is leading the process to challenge the act at the East African Court of Justice. He holds an LLM in Human Rights and Democratization in Africa from the University of Pretoria, an LLB degree from Makerere University, Kampala, Uganda, and a postgraduate diploma in legal practice from the Law Development Center, Kampala. His research interests are in the areas of LGBTI rights, the right to health, and children's rights. Adrian, we're so happy to have you here with us tonight. You have the floor.
Thank you so much, Ruod, and I'm really glad to be here. And thank you, Dr. Miriam, for the lecture on the working group. Really, that's something that was very interesting to listen to. I just want to share my experience from the Ugandan perspective as a user of the working group. In 2020, we had a group of 19 individuals who were basically detained, arrested by Ugandan police on the pretext of the COVID-19 regulations. The real reason why they were arrested, and which was told to them at their arrest, was because of their sexual orientation. So they arrested them because they are gay, beat them up, tied them with ropes, and marched them through the streets of the town where they were. They were charged initially with canon knowledge against the order of nature, which basically indicated that they were arrested because of their sexual orientation. Later on, the police officially changed their position and said that the arrest was because of COVID-19 regulations. So it became complicated because at the time they were arrested, that's the time when the president had declared a lockdown in Uganda. So public transport, we couldn't use private cars or public transport to get to them. And it took us more than 30 days as lawyers to go and visit our clients because the prisons authorities denied us access because of COVID-19. So we took them to court, and the High Court gave them an order that we should be allowed to access our clients because of the right to a fair hearing. In the meantime, we brought this case before the working group, basically complaining about the arrest itself, because the arrest was basically arbitrary because it was based on their sexual orientation, but also the treatment that they were subjected to was also largely because of their sexual orientation and gender identity. So we filed the case with the help of the RFK Human Rights from the US. And in the process, they were released after we secured a nolle prosequi from the prosecutors, and all the charges were dropped and they were left free to go. Later on, we filed a case with the High Court seeking compensation, and that case with the High Court is still pending up to now. So my major interest here is to share some of the experiences that we got from working with the working group. Of course, the first thing is that I noticed is about the speed and the simplicity of the procedure of getting through to the working group. It was just a matter of sending emails, and then there were no complicated forms to fill, and there were no difficult processes, and actually no costs that we incurred in doing this. One of the things I want maybe to point out is that as an African organization, we rarely, though we are lawyers and we've worked in this area for quite long, we are barely aware of the working group and its mechanisms. Now, I know it. I know about the working group. I've heard about it, but it's something you study about at school. That was, in my perspective, not something that you practically go to. So that was where the issue was. So I heard about the working group. So when RFK approached us and said, well, we could use the working group, we're like, really? Is that something we could do as African groups? And they were like, yes, we can do it. And eventually we got through to the working group, submitted our documents, and then we also got our opinion in a much shorter period of time. So the issue for me of awareness of the working group and its mechanisms to groups in Africa and other places perhaps is very critical, because I somehow feel that if we didn't have RFK supporting us, this case would never have come to the light of day. So I think sometimes it's easier for Western organizations based in Europe and perhaps the Americas to access the commission than it would be for us. First of all, because we don't know, and also it hasn't been largely popularized within our circles. So if us as human rights lawyers have a difficulty in terms of accessing, in terms of knowing and then accessing, then how does it then work for individuals who may scarcely be aware of this? The other thing is that the speed with which the working group works. So the process is really fast. We had that working group communicating back to the state almost immediately, and then the state also responding. Of course, during the process of the state compiling their response, we had to actually got to know that they were compiling their response, because for some of the facts and some of the issues that were taking place, they had to get them in a way from us, because largely the state is kind of fragmented. What happens in the police, in the prisons, is largely not known again to the guys at Foreign Affairs, who may be the ones who are compiling the responses. So we somehow got to know, and we participated actively, in a way actively, but then we also had to respond to what the state has said, but also bring to the working group the latest developments in the matter, which was also done. So now to show you that the comparisons, the working group opinion came out long ago, and up now we've not still gotten a hearing at the High Court where we're challenging violations in this particular matter. So that shows you the speed that the working group works very fast, very quickly. The mechanisms we have here in Uganda are really quite slow. Up now, we don't know when our case will actually be heard by the High Court. The other issue I want to comment upon is the issue of enforcement of the decisions. Indirectly, of course, there was more pressure on the government when we filed the case with the working group. The state kind of showed that, okay, you've taken us to this international body, we are going to respond, we are going to be active, we are going to do certain things. However, there's an issue around compensation. We already won a case in the High Court where we won compensation for the 19 people concerning the violation of the right to a fair hearing. That compensation, despite us reminding the government every single time, the compensation has not been, we have not yet gotten the compensation, and that's quite an issue around the enforcement. And of course, for the real reparations for arbitrary detentions, the matter is not even completed at the High Court. And we may win or we may lose it. You never know how the High Court takes to the issue, because the issue is strictly an LGBT issue. But for me, what I think is that if that becomes an issue in terms of failure to compensate, in terms of failure to enforce, then we can always fall back. I know there are follow-up options that are available at the working group, which you can use again to follow up and give more information on what's happening, and perhaps that could put more pressure on the government. The other aspect is working not just with a working group, but also with other special mechanisms. The independent expert on SOGI issues was also very much involved in our campaign, in our engagements. That also saw, because the issue of the knowledge prosecution being issued by the state, but the prosecution didn't just come out of the blue. It took out of pressure from different circles. So one of my experiences with the working group then is you work with the working group, but also you work with the other mechanisms, the other special procedures, so that you can speed up the process, more especially when someone's liberty is really at risk. So that is something that first we've learned, that the working group actually works. The group procedures are really quick and fast, and they can be utilized effectively, and that even us from Africa, we can also effectively use the system, and that it will work for us. But as a lesson for us, the lesson we picked is when do you start on the process? Because they have to write to the government, they have to do a number of things, they have to investigate, and someone meanwhile is in detention. So one of the things that we learned as us is that if you're going to engage with a working group, then you have to do it as soon as the violation occurs. We took quite some time from the time of the arrest and to the time of filing the application, to the time of filing the documents. So if we had started earlier, that would have made life easier for us. Maybe the decision would have come quite earlier than when it came. So for us, that's a big lesson, that you start immediately as soon as this happens. But also, the other lesson is that we can actually do it on our own. We can actually go and follow our documents as lawyers from here and get it done. So we expect and we hope that we're going to be engaging much more with the working group. And now that again, we have heard from the working group itself and also learning more about the procedures, and we're having these conversations that are going on, we think we shall be able to engage much more actively. But I also really recommend promoting the working group much more so that people get to know it quite a lot in Uganda, not just on issues of sexual orientation and gender identity, or even on issues of drugs, but also on cases concerning political issues, which has also become a big issue in Uganda, for being picked up simply for their political opinion. Thank you so much.
Thank you so much, Adrian. Is my audio coming in okay? Hello? Is it coming in okay? My audio? Hello? Can you hear me? Yeah.
I can hear you.
All right, great. Sorry. I thought there might be feedback. Thank you so much for taking us through your experience, and I'm glad to hear that your experience with the working group was a positive one, and that it was successful in the cases that you pointed out. So now that we are at the end of the presentation, we are ready to take on questions for our speakers today.
I have
So we
one
have.
there.
All right, great. Thank you again, everyone, for all your insights and all the information that you provided us today. Maybe to get us started on the questions, if I were somebody caught in a situation that constitutes as arbitrary detention, what can I do? What is the first few things that I should do as somebody who is detained? Anybody from the panel? Maybe we can start with Dr. Miriam.
Yes, thank you so much, Ruth. First of all, allow me to congratulate Adrian and also Yada for the presentations that they have produced today. And I'm really happy, Adrian, that your experience with us has been so good. But in order to answer that question, I can link it to what you have asked. You are absolutely right. And that's why I thank all the group for allowing us, for inviting us to disseminate our work. We are very short in that department. I'm going to share something. We have this honorific position. We don't receive any salary, and we have only the money, the budget to do 2 visits per year. So we are ready as experts to go wherever we can, no, with the support either of UNDP or an university, etc., in order to make the public aware of how they can defend themselves. So that will be my first advice. The second advice would be to present the case as soon as you have been arrested. You have gone, and this is also answering a question, no? You have gone all the way to the High Court. You didn't need that. You should go directly to the working group, and the working group will write to you, government, that has the obligation to release the person or the group of persons. These were 19, as you told me. But then also, now that we are at the level, in the stage of reparation, you should come again to us and give us a follow-up letter so that we can intervene. In this follow-up letter, you can say, okay, we have not received any reparation, we are in this situation, and then we please ask for our intervention so that we can say, we have already decided these people has been already are already at liberty, so you must pay the reparation because it's an obligation. End of the story. Is binding. Our decisions are binding. Now, Australia. Ooh, we were 3 seconds to be in the plane to go to Australia when the COVID-19 struck. So now, in November, hopefully, um, as we say in Latin America, God willing, I will have a meeting with the ambassador, or with the permanent representative of Australia in Geneva in order to establish the possibility to visit Australia. But that will be most likely in 2024, because now we will be visiting Canada and maybe Bahamas or Tunisia. We are not sure now, but this is the process. I already said, in the moment that you get detained, please come to the working group. You have already heard from Adrian that the situation is, I mean, the process is quite expeditious and also very easy to address. So thank you. Any other question, please?
Thank you, Dr. Miriam. There's one more question here in the comment box. Could you tell us what are the most common violations you have witnessed in country visits regarding drug control?
I am speechless. I am speechless because drug control, I mean, people treat people, I mean, we have to make the separation, no, between drug trafficking and those who use drugs for personal issues. So drug control is used as if everyone were a drug trafficker. Number one. Number two, corruption. I must say, although this is very sad to say, when in this war against drugs, corruption is the first thing that we have to check. You start paying, and particularly those who pay are the ones who are trafficking drugs, while those that are using, they are treated in a way that is horribly humiliating. The other cases, rapes, mistreatment because you belong to a particular category of sexual orientation. This is terrible. Blackmail to sex workers in every possible sense. And the horrible situation of people using drugs that are suddenly, that they needed, that, and in any prison so far, I have been able to see that inside the prison there is a particular problem, a program supporting the victims. So they are just placed in the prison, locked down, and forgot about them. That's the most terrible issue. There is such a list. And the other issue that also we see quite a lot, these drug prisons are used to combat political enemies, or when groups of power want to, disappear a person, they mix them. Everything is staged. So they mix this with drugs, and they just place the person out in prison, and they erase the problem. Say, for example, I had five farmers that they were fighting for, not to destroy the only river they had. They were accused to be in the drug trafficking issue, using and producing, and this was an absolute lie. And they were there in jail, pre-trial detention, for 8 years. Could you imagine being tortured? This is the most terrible thing also, no? The most common violations is the ones that I have said. Corruption allows these possibilities to be endless, unfortunately. So I hope that will answer the question.
Thank you so much. Yes, it did, Dr. Miriam. Thank you for sharing your experience with us. Maybe for everyone in the group, another question is maybe as civil society actors, organizations who may or may not be involved with any cases on arbitrary detention. What maybe should our main takeaways be here during the session? And how can we help if we're not involved in any cases? What can we do to help people that are detained arbitrarily right now? Maybe we can start with Giada this time.
Thank you. I was hoping Adrian could start because his job is actually much more important than mine. So I go with the theory, but then I look forward to hearing from him. I think one of the things that emerged clearly from our conversation today and from Dr. Miriam's intervention is that we need to, and actually also from Adrian's intervention, is that too often we don't even know what we don't know. So we don't know which rights we have, and we don't know who we can appeal to when our rights are violated. So a key issue that we see in a lot of cases is that actually we don't know when we are or where our community members are in a situation of arbitrary detention. As we were saying, it's much more comprehensive than, you know, someone that comes to my house randomly and puts me in a jail. It goes much further than that. And there are also cases where a detention could start legally, let's say, but then becomes arbitrary because of the conditions that I'm put in, because of how long I stay there, because I'm treated. And so the first thing that we really have a responsibility to do is educate ourselves and educate our peers and our partners so that we know which rights we have. The second thing still connected to that is educating ourselves about the safety nets that we have around us. The working group, of course, is a huge one and is there and is ready for everyone that calls up to them. But then we also have those close to us, like Adrian's organization, like Attorney Kati's organization from the Philippines we heard from this morning. There are a lot of people that do this job that can help us at the police station, in jail, but that can also help us linking us to the working group, for example.
Exactly.
Even Armed Action International as us, like we spend a lot of time in front of our laptop. We do have time to write emails. We do have time to do a lot of the sort of boring work that connects the working group with victims of arbitrary detention. But often we don't know of the existence of each other. So something that we need to be better at doing is communicating about the rights and the opportunities. I stop here. Adrian?
Thanks, Giada. Adrian?
Yeah, thank you so much. I would just want to maybe to make a comment. Like, yes, we need to popularize the working group and make sure that people use it. However, from my experience, there is a little worry around, for Uganda's case, security and safety. And I wonder what Dr. Miriam will say about this. Already I can say this, that one of the people who was among the 19 was murdered later on. And trying to convince people that there's no linkage and connections between what we do and the murder by unknown people is something a little bit difficult. So our clients find it a little bit complicated, work with international mechanisms, because then how do you guarantee your safety and security? And how does, because your name is out there, like you are the people, you know, your government has done something, and now we've been labeled as foreign agents in a way by our government. And right now there's a crackdown on LGBT organizing in Uganda. So it's a little bit complicated in that respect. I wonder, Dr. Miriam, how the issue of security and safety can be guaranteed for people to be able to use the mechanisms much more. Thank you.
If you allow me, Ruod.
Yes, go ahead, Dr. Miriam.
Okay, Adrian, we have a whole chapter that I have forgotten, and I apologize for that, which is called reprisals. So also we can issue this urgent appeal telling the government that these particular persons are under our watch because they are not allowed to exercise reprisals, not from the state, not from their own society, because we have seen the two cases. So this is a follow-up. This is another chapter that we do. But of course, I am aware, even us, when we visit the different countries, we are traveling with security because people is very sensitive. People are very sensitive when it comes to our work. But this is something that will change as long as everybody knows their rights. When everybody knows their rights, they can get together. And what Yada was saying is exactly what we need to push to get, to do like a human chain in order to be protected, all of us. No, because it's not only those who are using drugs, it's everybody, particularly those in poverty, vulnerable people, asylum seekers, migrants, children, women. So it's terrible. And sometimes they face the penalty, as also Yada said in her presentation. So my recommendation on this would be, let's build like a human chain so that we can support each other with NGOs, with civil society. This is why I started my presentation saying sounds from the core of my heart, because you are allowing us to disseminate our work. So that would be my recommendation. Thank you.
Thank you. Thank you so much, everyone, for answering these questions. We have one last. So, what are your pockets of hope for this work on arbitrary detention? Just to end on a light note, what do you see as our ways forward as organizations who work on arbitrary detention? And maybe any closing statements that you have before we end the session. I'll start with Adrian this time.
For me, what I would really end with is the realization that it works, and that's important. The fact that the government actually does listen. I was surprised when the ministry got in touch about this. I'm like, really, guys? We've been hunting you down. Now you are hunting us down to give you some answers. And for me, that made a lot of sense because it was so rare. Like, we've been hunting them down. Now they're looking for us to give them answers and responses and updates on what is happening. So for me, it's a mechanism that really works. It's a mechanism that we can easily access. Like I always repeat that, even for us from Africa, because for us these things look like they're far. They are in New York, they are in Geneva, they are wherever. But if I can write an email is not in Geneva, it's not anywhere, it's an email. It can get there and the decision can come to me via email. So we need to, to use the mechanisms, but also I've learned the issue of follow-up. Like our decision really needs to be followed up for real, because the government just paid no attention to the decision at all. And we've been also quiet and silent about it. So it's high time for us to follow it up, but also push more cases, because the more you push the cases, then the more the government understands that, you know what, you simply can't do this, and people will just sit down and look at you.
Thank you, Adrian. We'll go to Jada and then Dr. Mira. Jada.
Thanks, Rod. I'd say especially after a key moment for us in our engagement with the working group has been the study on drug policies that has been published last year. And reading the study and really going through 20 pages of examples of violations of human rights in the context of drug control is a bit bleak and really makes you think that rather than progress, we're going actually the opposite way. But then if we can actually, and this is what I see as progress maybe, the thing that we learn from there is that we're now actually talking about drug control in the context of human rights. We're finally a clear idea, a clear understanding of what a human rights-centered approach to drug control means, what an approach to drugs that's effective but also humane is. And that's also thanks to the work of civil society and of institutions such as the Working Group on Arbitrary Detention, which has been one of the first, going back days and years, that really has started systematically looking at the ways in which drug control was legal but unjust. And it was one of the only institutions that really, UN agencies, UN procedures particularly, that we could look at and go to member states and show evidence from, that really was telling us this is a violation of human rights in the context of your approach to drugs. And so if we're now at a stage where we can call out human rights violations in the context of drug control and call for drug policy reform and sometimes get to that drug policy reform, is also thanks to this work. So it can seem again bleak and slow sometimes, but really there is progress along the way. We just have to continue going. So I just wanted to say thanks again to Dr. Miriam for being here, to Adrian for doing what he does, and to everyone for being with us today. Thank you.
you, Jada. And finally, Dr. Miriam.
Thank you so much, Ruth. Uh, we have to see a reality to comprehend the current reality of the world. We are living a world of hate, violence, war, and there are few spaces that we need to defend, and we need people to know that there is hope. So the working group works. I have been a witness of people that has been, a threat, that has been again put at liberty and receive back their freedom because of our work, people that we don't know and we will never know, that we won't meet. We are independent experts. This is a little space, 5 people fighting, trust me, and working day and night because, as you know, Adrian, the opinions are really long opinions because we have to analyze legally everything, every detail. So, but we do it with that hope and with that convincement. We are in a space of hope, and we will hang on there because we believe that now what the world needs are answers, true answers, answers that will work and that will give people back hope and the reassurance that the law exists and that still you can rely on it. That would be my words, and I get very emotional. I'm sorry. This is a very Latin American reaction, but I am so happy to hear, Adrian, that actually it has worked because yes, it has worked. And sometimes you receive uh, news from Mexico, Honduras, Philippines saying it worked. Like we say it worked. We are so happy with that. So hope and fight also, and keep us together supporting each other. Thank
Thank
you.
you.
Thank you
Thank you
so
so
very
much.
much.
And that was really well put. We are in a space of hope, in bleak processes like this. There are pockets of hope, and I'm so glad to have shared the session with three of you. Again, I'd like to thank Adrian, Giada, and Dr. Miriam for being here today. We'd like to thank the Luring on the Margins Network for also helping us co-host and for producing the video. So you may find out more about the Luring on the Margins Network on the website lotmnetwork.org. You may also want to Google the Working Group on Arbitrary Detention and also find out more about the wonderful work that Adrian's group HRAF, Human Rights Awareness and Promotion Forum, does for Uganda and the LGBTI people. So thank you again, everyone, for joining us. Hope you all have a great day and great evening. Goodbye.
Thank you. Thank